having hearings where the prosecutor is saying the same thing. So he's betraying or naming names and nothing happens to those third parties, mainly because it's his word against theirs, and the others are saying, the ex-president is saying, I never did that, I have nothing to do with that. So it seems like a repetition that is wasteful.
You're really singularly positioned. You've been following this from transitional justice before various institutions, in various forms yourself for more than a decade, right? So that really, there's kind of no one who's going to, that's a really great positionality that you enjoy.
So of course a 60-year plus conflict with 9 million victims will shape the meaning and function of repetition in ways that differ dramatically from a shorter, more contained conflict.
It just means we need to kill more people, or other people need to be killed. And I don't understand that.
You are not allowed to try people for the same thing. So to what degree are these cases that you're following, do they run afoul of any of those double jeopardy? Is there something that happens institutionally if you're embedded in a judicial system and then you step out, right? So I think your lawyer hat can let you ask those questions about where protections lie and what's repetition. Because in my mind, what you're describing is a certain kind of push and pull of repetition.
Peaceful way out to conflict is necessary. I won't abide to any other conclusion.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
Good afternoon, all. It's my pleasure to welcome you to the 10th seminar in Phase 5 of our International Interdisciplinary PhD in Progress weekly seminar series organized by the Global South Network. Before we begin, I would like to thank my colleague, Dr. Norman Royat, lecturer in law at the Leicester Law School, and founder and chief convener of the Global South Network for organizing this weekly seminar series. I am Hakeem Yusuf, professor of global law at the School of Law, University of Derby. I have done extensive research on the role of the judiciary in transitional societies, which has attracted international attention, including my appointment in 2011 as a commissioner on a Truth and Reconciliation Commission in Southwest Nigeria. I have consulted for the United States Department of Justice, Majesty's Government of Gibraltar, the International Commission of Jurists, Geneva, and others. And it's my pleasure today to chair this PhD in Progress session, and I look forward to learning about the presenters' research and engaging in the discussion that follows. I have the pleasure this afternoon of being joined by two discussants for the presentation. First, Dr. Johanna Amaya-Panche is a senior lecturer in international relations and politics at Liverpool John Moores University and the program leader for the Masters of Arts in International Relations. She previously held roles at the University of Edinburgh and University College London. She has worked extensively with international organizations such as the European Union, USAID, and UNDP. Her research focuses on peace building and Latin American issues and has been featured in several international media, including France 24, The Dialogue, The Canning House, The Independent Diplomat, and the Inter-Ethnic Committee for Implementing the Peace Agreement in Colombia. Second is Dr. Kerstin Carlson, who is an associate professor at the Department of Social Sciences and Business of the Roskilde University, Denmark. Her research focus is transitional justice, criminal law, terror law, and trials. She's currently following terror trials in Denmark, Norway, and France, and also attending where possible. Our publications are in conversation with critical legal studies scholars as well as national law scholars and criminologists. She's also following the work of the Jurisdiction Especial para la Paz, the JEP in Colombia, the special court created under the 2016 Peace Accord in Colombia. This research examines the institutional development of that court, the legal doctrine it is producing, that is its jurisprudence, and how this addresses social and political challenges in Colombia. Here, our work is in conversation with political theorists, basically decolonialism and transitional justice scholars. And now, finally, it's my great pleasure to introduce our guest speaker for today's seminar. Sofía Cabarcas Maciá is a PhD researcher at Sciences Po Law School, Paris. She's a Colombian lawyer and anthropologist with a master's in science from the London School of Economics. As a PhD researcher at Sciences Po Law School in Paris, she works in the intersection of anthropology and law to explore methodological questions on the ethnography of trials to enlighten how the law is performed and formed. Before starting her PhD, she had worked for 10 years in transitional justice mechanisms in Colombia, including the Office of the High Commissioner for Peace and Colombia's First Truth Commission. Today, Sofía will present part of our PhD thesis, our PhD project actually, titled Tracing Reputation in Transitional Justice Hearings in the 21st Century. She will speak for about 30 to 35 minutes, followed by 5 minutes of comments each from our two discussants. And if time permits, we'll then open the floor for up to 10 minutes question and answer session with our eminent audience. So, Sofía, we are delighted to have you with us today, and the screen is yours.
Thank you so much, Nauman. And I'm so honored to be here and with such esteemed chair, Kerstin and Johanna. And thank you, Nauman, for the invitation, and Hakeem for the very, very generous presentation. Uh, I prefer to have a big discussion about this, so I'll make my presentation a bit shorter, I think. Just to start to say that I had been working on these ideas and questions for a long time before I started my PhD, and I started my PhD a bit later in time. But that has been also a wonderful opportunity for me to do this, because finally I had time to reflect on all those questions and unanswered questions I had when I was a practitioner. I have a presentation to help think more clearly about my ideas and how my argumentative thread has been. But I didn't think that you will all be such experts in the transitional justice system in Colombia. So maybe there's some details that are not necessary in the contextual sense. So as Hakeem said, I'm a lawyer and an anthropologist, and this explains my thesis, my life choices, and why I'm here, basically. So I think that's very important. Early on, I started as a law student, and I always felt something was missing. So in my second year, I started studying anthropology as well. And this double undergrad or double discipline in my life has made me learn about the law in different ways and about anthropology as well. So why am I looking into this? Well, as you already know, Colombia has a history of more than 60 years of armed conflict, and a lot of people from my generation were compelled or spoken by transitional justice. Transitional justice became this dilemma, this big concept, or this big opportunity, especially in social sciences and law. And it became this big question, right? About what would work, what should we do with a violent past, and in the case of Colombia and other cases, ongoing violence. So this is very important. It's not of course, not a linear view, and the past is not something that we can look at and touch, but it's actually something ongoing. And this is how the questions are posed in the Colombian context, but I think that also in most of transitional political transition context, this is the question, right? So basically, to understand, we had a first transitional tribunal. It was embedded in the ordinary justice system, but it had newly appointed judges called Justice and Peace, Justicia y Paz. And it was the product of a very polemical and criticized peace agreement between the government and the paramilitaries. And the exchange was 8 years of sentence in exchange for truth. And the tribunal started working in 2006. And it went ongoing under a lot of challenges, a lot of critiques, a lot of scandals as well. And up to date, up to 2024, it had 88 sentences and 873 people convicted. And it prosecuted ex-paramilitaries who had demobilized and guerrilla members who had demobilized. Most of the discussions at that time, and my project is very much historical, referred to this transitional mechanism not being a transition at all. So the main phrase to describe this was a transitional justice without a transition. And it became more of a permanent question, but also a question about its efficiency and how long would it take. It's still ongoing today. Afterwards, of course, with the movement towards human rights and anti-impunity movement worldwide, Colombia had a lot of other transitional methods installed, and a victims unit, and the identification of victims and victims reparation, so more administrative institutional forms. And in 2012, the fifth attempt to sign a peace agreement with the FARC guerrilla, which was the biggest guerrilla in South America, started. And this was the fifth attempt. So Colombia has a big history of trying to solve the armed conflict through negotiation, through peace negotiation. So the history of violence in Colombia is parallel to a history of peace efforts. So this is very contradictory, but also very characteristic of the Colombian context. And in this peace negotiations, we finally got a 2016 final peace agreement with the biggest guerrilla, and it had 310 pages with a lot of reforms and institutional transformations. It was not only disarmament or amnesties, it was something greater. And it created a new jurisdiction, this time a much more integral transitional jurisdiction, and not embedded in ordinary justice, so considered as another jurisdiction, which is the Special Jurisdiction for Peace, the JEP, as we know it for its initials in Spanish. And it also made part of this new judicial transitional justice mechanism in an integral peace system, which was composed of a truth commission that lasted less than 4 years, the peace jurisdiction, and a humanitarian unit for the search for the disappeared. And up to date, this the Special Jurisdiction for Peace started in 2017, and it has one sentence and has convicted 12 most responsible parties. And it prosecutes ex-guerrilla members that are signers of a peace agreement, and also state agents. So the prosecution of state agents is very much new in this jurisdiction. So as I told you, I started as a lawyer and an anthropologist, and my undergrad thesis was an ethnography of a 2012 and 2013 hearing of the Justice and Peace, of the first model. So I attended to this legalization of charges hearing that lasted 10 months. And I did an in-depth ethnography about the ritual of reconciliation. When was this happening? When was forgiveness being asked? Was this a thing? It was very interesting because the hearings back then were public, but not publicly transmitted or diffused. So what was happening there wasn't really part of the public discussion at most of the time, but what was happening was very interesting. And since then, I've been taking field notes. I'm an anthropologist always. So even if when I was working 10 years as a practitioner, I would have my field notes and I would have pending questions. I made this table just to get a grasp of what the Colombian transitional justice system looks like and how it could be compared to, for example, Yugoslavia or Rwanda. And the justice and peace mechanism is still ongoing, and it doesn't have an end date, but it definitely, we want it to have an end date, or there's been a lot of projects to make it more efficient and to come to an end, but it's been very difficult to do this. And that a special jurisdiction has an end date, possible end date, maximum end date, the 28th of November in 2037, but it could be before. So what is my research and what I want to receive feedback on is I saw something because I'm an anthropologist standing and attending hearings that you could only see when you use traditional tools of anthropology, such as thick description. So thick description is this coined concept by Clifford Geertz in the 70s, in which paying attention to details could tell you a lot about what's going on. Of course, anthropology has a colonial background, and it's very important to question the methods. And this is sort of what I'm trying to do, how traditional methodologies of anthropology can give us new insight into the legal field. But anyways, when I was using this thick description methodological tool, I noticed there was something there going on that was repeated. And I could only see this through time. So it wasn't only in the 10 months that I attended to a hearing. Of course, there are legal forms that are repeated, but I also saw the same testimonies in other transitional justice mechanisms. So the prosecuted that I saw in 2012 and 2013 give their deposition and their declarations and their testimonies and ask for forgiveness, then went to the first Truth Commission in 2021. So a time span of 9 years, the prosecuted comes back to another extrajudicial mechanism. And I feel some parts of the speech, some parts of the procedure, but also some parts of the whole narrative being repeated. And of course, this could be a memory exercise, but then in 2023, the prosecutor comes back to the special jurisdiction for peace, so another type of hearing, and I listen to similar things. So this repetition through time indicated me that there's something there to be analyzed. There's something there worthy of looking at. So my main subject is, if I use this method, I could trace repetition as a practice, how it looks in the courtroom, and this has a lot to do of how the law is performed. So law's performance is a specific subdiscipline in law. It comes from the intersection between law and social sciences. And I think that this could lead to a novel analysis of what transitional justice is, how it has come to be, and how this has influenced the rule of law and law itself. So there's something performative going on here. Ultimately, what I'm trying to do is a Latour, although I know that that's a long way, but describing how the law is being formed through this specific practice of repetition in these hearings. So repetition is the word that I used at first because that's what I felt. So it's a concept that has affective implications. So it's sort of a deja vu, it's sort of feeling something is repeated, something that I've already lived. And I was called by the concept that Deleuze uses of repetition because it's more transformative and it has more potentiality. So the word repetition in English has a lot of roots, and it could be an action, but it also can be a plain concept. Repetition is used in other disciplines, very much different from the law and anthropology. So in interior design, repeating patterns gives calm to the people. So it's to generate calmness and steadiness. In the arts, doing repetition or something repeatedly can be, the repetition of a theater piece, but also the repetition of an art piece. So copies, there has to be a first for there to be a second. So this also has to do a bit with time. And in speech and narrative, repetition is a technique that we use to remember, also to convince, to compel, very much related to rhetoric. In the courtroom, repetition is performed by actors. So it is definitely something to do with the actors and the network in the courtroom. So, forms like all rise for the judge, well, that's something that is indicating that we are in a hearing, repeating the articles and the frameworks and the legal frameworks, well, that's part of the performance and it needs to be repeated. And there's also some things that we repeat to signal that we are in a hearing. So I was also wondering what was signaling that we were in a transitional justice hearing, how that was different from ordinary justice. And repetition has been a sideline concept used in some sociolegal studies of trials and of justice, to talk about trauma, to talk about how we repeat trauma in the courtroom or narratives of trauma, or how repeating victimizations can be re-victimizing or can be a way of discriminating gender violence victims, for example. So the repetition I'm seeing, as I said, happened in 2012, 2021, and 2023. And right now, I am back in Colombia doing field work and attending hearings. So I'm looking at repetition in 2025 and 2026 as well. So why repetition? And repetition is not a legal concept yet, I think. So I'm trying to theorize about repetition as a legal concept. So in the doctrine of law, there's a lot of, in legal reasoning, there's a lot of things that are anti-repetition, I would say. So choice of law, jurisdiction, res judicata, they're all legal tools to avoid repetition, right? And to become efficient. In criminal law, it sounds like repeating something would be inefficient. And the principle is that we domestically in criminal law prosecute all wrongs to avoid complementarity mechanisms that could, possibly harm sovereignty and legitimacy of states. And in procedural criminal law, there's the principle of rationalization of the criminal action. So going against those most responsible, and that also seems counterintuitive to repeating something, having time to repeat. So 1, 2, 3, or even giving resources to such repetition. And in transitional justice, it's similar to socio-legal studies of trials. So in the Hakeem trial and in the Nuremberg trials, a lot has been talked about how we repeat the story of trauma. And how political trials have a huge burden, and trying to resolve something traumatic, well, you end up repeating itself. And because there's something unsettled, is very difficult. So taking on Deleuze's philosophy, that was very much, it was different at the time. He was proposing some sort of singularity. And he was seeing repetition in a more positive way. And he said that repetition was not something similar as we always see the law, but is something that has a difference. So I have felt that the comparison of repetition to twins is very much enlightening. So people who are twins are similar, but are not the same people. So it's depending on that difference. So for this thesis, for my thesis, if I use repetition in these terms and I can theorize about it in the courtroom, well, we could break through important discussions about how ethnography, looking at a trial, being there, doing thick description can be emancipatory, can be transformative. And if this is a way to talk about empirical methods in law, which is what I like to talk about, basically. And I've been teaching about this back in Sciences Po. So going to the specificity of my thesis, I have followed the testimony of one prosecuted ex-paramilitary, Salvatore Mancuso, in time. And this repetition that he engages with has a lot to do with his identity, of course, of what he is, negotiating. So his liberty coming back to Colombia, and his freedom after the sentence he paid in the United States because he was extradited and then extradited back. But there's something in what he tells in these different transitional justice models that can speak to the concept of repetition. So my analysis is not only of a prosecuted, of a perpetrator. He's the anchor because he has been there. But definitely I want to look at repetition as a form that victims can profit from, or also calling for him to repeat a speech or a declaration. What does that mean for victims in the process? So, I mean, this has been a long way. The paramilitaries were one of the actors in the armed conflict, and Justice and Peace has done, has more than 800 sentences explaining what the paramilitaries were, what paramilitarism is, but it seems like there's still pending questions about what paramilitarism is in Colombia and what that means for public policy decisions. So it has been a long way for the victims of these specific criminal group, and they have had milestones. So of course there was a sentence in 2014 against a lot of the paramilitary blocks, and some of them have gained restitution and gone back to the places that they were. So the way land disposed there has been restitution, there has been some reparation, but overall there's still a long way to go. So this has been some of the advances, but of course victims still feel like there's a lot to be said and done. This is a constant tension in transitional justice, but I think in this case, it's something that it's worthy to understand. So when he said in 2012 in a hearing, he was repeating the complicity of the ex-president Álvaro Uribe Vélez in the formation and the workings of a paramilitary group. And the first time that he said that, I was there in the courtroom, the first time he said it in a judicial hearing. And then he said it again before the Truth Commission, and he linked the complicity of the ex-president to the massacre of Diaro, which was a terrible massacre in Antioquia, displacing and burning a whole village. And then he repeated this before the Special Jurisdiction for Peace in 2023. And he always speaks of others. So there's a betrayal or a mention of others, of third parties, like the ex-president and others, so ex-militaries, businessmen. And this is what seems to be repeated in his speech. And he seems to be repeating this when a magistrate or a third party, a commissioner, or in this judicial or extrajudicial hearings, he's asked about what new truth he can contribute. What is new about his say? He has been participating for the last 13 years. What is new? And he starts naming names, if you want to put it in a way. So what is the problem here? Why is this a problem worth looking at? So there's something that got clogged. So it is in the general parts of the hearing where we're talking about the concept of the context of the armed conflict. So we have had many concepts to describe this conflict. So protracted, long-lasting conflict, ongoing conflict, a webbed conflict because of all of the actors and things happening. So for me, maybe looking at repetition can be a way out. And my research question is, how did repetition become an indispensable practice of transitional justice mechanisms in the 21st century amid ongoing conflicts? And this has a lot to do with what I started saying, which is transitional justice as a formula has had a lot of questioning today, and the ongoing characteristic of this there's a lot of things to question about transitional justice in itself. So because I'm a lawyer and anthropologist, I'm working in the intersection of law and anthropology. I'm using ethnography as my main method. I'm doing post-analytical ethnography of my previous field notes, of course, and what I did back then in 2012, 2013. And I'm doing new participant observation. And my purpose right now has been doing this new field work is to identify what is the function of repeating something in this performance of law. And if it can be used by victims, as I said, victims of crimes against humanity. And this, I have a lot of fields and subfields, but I'm trying to narrow that down and talk about law's performance and end up saying something about what the law is. And so currently I'm doing an ethnography on macro case 8 and 11 at the Special Jurisdiction for Peace, which are, the first one deals with the illegal alliances between public forces, state agents, and paramilitaries in the killings and harms to civilians in the armed conflict. And macro case 11, which is the first gender focused macro case in the special jurisdiction of sexual and reproductive crimes during the armed conflict. So there also has been a link of how some of the illegal alliances between state agents and paramilitaries led to sexual violence. This is very novel and it's still in the workings, but it's been wonderful and very interesting to see how these two macro cases can have common argument and thread. So I'm still doing this. I'm still looking at it. So that's what I would like to talk with all of you about. So I have noticed that I can see repetition after a lot of hours of hearings if I stay. So there was the other day a very tense hearing, and I was really, I was tired. I thought that nothing was going on. And up until the 10th, the last 10 minutes, I noticed what the repetition was doing, what repeating some parts of the narrative or the testimonies was doing there. So it's related to this holding on, but also it relates to my first feeling of repetition, which was related to frustration. So I've also been advancing in interviews, and a lot of interviewees relate this action of repeating or doing repeated things in transitional justice without a solution to frustration. And I have come to distinguish frustration as an affect from disappointment. So when we say we're frustrated, it means that we think something is wrong or that we should be doing something better, but that we could do better. So I'm frustrated because I couldn't do this, but I can do it better. But then disappointment, I found it in some interviews, and it's been very complex because disappointment is mainly the opportunity is lost. There's nothing to do there. We are repeating this is inefficient, and we will keep on doing this because it's the only thing we can do in the face of horror and in the face of violence. I've also found that some procedures depend on this repetition. So in order for macro case 8 or 11 to get to some sort of truth and some sort of retribution in these cases, they depend on repeating a lot of formulas and repeating narratives and coming forward and some of the narratives coming back to the courtroom. In others, I found that repetition is there, but it's insufficient to deal with such horror in the armed conflict. So that's my research, and I can't wait to listen to your feedback, and thank you so much for listening.
Thank you so much for doing that well within time. Despite its complexity, you made it accessible. Thank you so much, Sofía. So I will call on Johanna to give us comments or questions regarding Sofía's presentation, possibly in 5 minutes.
Great, thank you, Hakeem, and thank you very much, Sofía, for this thoughtful and compelling presentation. I would like to begin by emphasizing how important and timely your research topic is. I think that asking how repetition becomes an indispensable practice of transitional justice in ongoing conflicts is not only innovative, but it touches a core empirical puzzle and social legal studies and open space for deeper reflections on effects, legal performance, temporalities, and of course, truth-telling. And this is an excellent perspective. You articulate very well with clarity your argument. I also very much like your decision to focus on closely analyzing the macro cases 8 and 11. I think these are highly relevant cases in the context of Colombia, and they give you enough variation and enough complexity to explore repetition, not simply as a textual or discursive phenomenon, as you mentioned, but as something that emerged through practice to the relational dynamics between magistrates, perpetrators, victims, and the overall actors involved in transitional justice. So I think from my perspective, this choice strengthens your research project. So now let me move to offer some few points that I think will help you to sharpen the contribution even further. So first, when you present the argument, the case selection, and particularly this table comparing your country cases, the other country cases, Yugoslavia, Rwanda, and Colombia, focusing on the special jurisdiction for peace. I think this is a very helpful starting point. But to make that comparative effort more robust, you might need to account for conflict duration and scale of victimization to make this case comparable in scale. These two elements are not just two background factors or categories. They are constitutive elements of how transitional justice is designed, sequenced, and socially performed. So, of course, a 60-year plus conflict with 9 million victims will shape the meaning and function of repetition in ways that differ dramatically from a shorter, more contained conflict. So perhaps bringing those numbers in will help you to anchor your comparison and to avoid the risk of perhaps defining a superficial equivalence between tribunals. And second, I will encourage you to articulate more clearly what exactly repetition is, and beyond that, what is singular in the cases you analyze. You also mentioned singularity as another related concept. You describe repetition as a concept that emerged through thick description of hearings, and I think this is excellent, but to deepen the analysis, you could clarify some questions. For instance, what patterns of recurrences happen across cases and across time, and perhaps it will help to contrast with what moments are singular, contingent, or linked to specificities of a perpetrator, or for instance, a magistrate or a transitional justice moment in time. And I think these distinctions matter because repetition is meaningful precisely in the tension between recurrence and singularity. And related to that point, if cross-case comparison is one of your goals, you might need to define the criteria you are using to compare them, the two macro cases. I wonder if you are comparing legal procedures, performative practices, effects in the courtroom, as you mentioned, the institutional mandates of the tribunals, or the expectations placed by victims or perpetrators. So I think making those analytical points more explicit will allow you and the project to scale from rich ethnographic detail to a broader theoretical contribution. And finally, I want to encourage you to embrace even finer grained analysis in the hearings. You have the data and your ethnographic eye is excellent, and this project will shine most when you zoom into those micro moments where repetitions become effective, where it produces frustration, as you mentioned, and where it reveals the limits of legal truth and the emancipatory potential for victims. So I think those small details are important to highlight the originality of your project, and the overall contribution. So I will leave it there. Thank you.
Thank you very much, Johanna. That's beautiful. It's getting better and better and better. Can we have Kerstin, please?
Hi, everyone. Thanks so much for inviting me, and it was really a pleasure to be here. I want to start by echoing what Johanna said. I want to really encourage you, Sofía, with this project. It's really interesting, and there's always something very powerful about trying to find the space between different fields. So I think you've been really reflective about what it means to be an anthropologist and ethnographer, and then also a practicing lawyer, and what that can give you as you walk into this space. So as a person, I'm also trained as a lawyer, and then I dabble, I guess I would say, in social sciences. So I think there's always a nice moment of this where we can kind of try and use the strengths from both. So I think the first place I would want to kind of challenge you a bit is on this question of repetition as a legal concept. I think you put on one of your slides, right? Because the lawyer hat in my head was like, wait, what? Is that right? And I think in your presentation, you're really thinking more about repetition as an anthropological or an ethnographic concept. And that's really powerful. But if and when you want to connect that to legality, then I think you need to be, if I may, a bit more rigorous in how and what. So when I started, but again, it was I think it woke me up. So then again, my lawyer brain woken up. I thought, all right, how exactly does repetition work? And the first thing I thought about was double jeopardy, right? Which is a huge problem the HEP has. Like, you are not allowed to try people for the same thing. So to what degree are these cases that you're following, do they run afoul of any of those double jeopardy? Is there something that happens institutionally if you're embedded in a judicial system and then you step out, right? So I think your lawyer hat can let you ask those questions about where protections lie and what's repetition. Because in my mind, what you're describing is a certain kind of push and pull of repetition. So that would be, there's the kind of the pull away would be the ways in which we're protected. You also said that repetition was inefficient. You had this kind of, and then I started again because you had triggered my sort of lawyer hat. I thought, is it inefficient? And it felt to me like some of the cases you named were precisely examples of efficiency, right? Repetition becomes a short form. So we don't have to demonstrate the legitimacy of a tribunal because it repeatedly operates in a way that we recognize as court-like, right? So that actually there can be efficiencies in repetition. And I don't know if the places that you're describing are like that, but it seemed to me that some of what you're doing now, some of this work might be about creating criteria. So I felt a little bit lost in your presentation about the actual object of your study. What exactly are you looking at? When you're done, what will we know about the work that you've done? And here now, I mean, you're really singularly positioned. You've been following this from transitional justice before various institutions, in various forms yourself for more than a decade, right? So that really, there's kind of no one who's that's a really great positionality that you enjoy. So you have the capacity to try and take all of that experience that you have and that critical eye, and then to theorize from that. So to tell other people what sorts of repetition are interesting, what can repetition do or not do, where is it a short form, where is it a challenge, where is it a reassurance, right? So I think that your object here is about this kind of push and pull of repetition, but I think you need to narrow things down, because if you can't, you need to be able to say what something isn't, right, in order to be talking about what something is. So you want to be careful that repetition isn't everything, right? That you push out from and say what it is that you're not looking at, right? So you're making a category. That category will have certain things under it, fall within it, and certain things that don't. So there, I think you want to push your definition a little bit more. And I think you've done a lot of anthropological thinking about this. Now I think you need to do a little bit of more maybe legal thinking about this, right? So invite yourself to think. And I think you've picked a really great spot to do that. Like I said, I think particularly so I don't know Justicia Paz nearly as well as I wish I did, but with the HEP, I know with the HEP, there's really a problem in terms of the case. Okay, so these are not the cases you're looking at, but when you look at case 1, the only case that's been finalized, right, and case 7, one of the resistances there is right now, case 7 is stalling, and it's stalling because of repetition, right? So you've really grabbed something. I think you've got your teeth in something that's really important. And then I think you want to ask yourself, what work is this doing, right? So because there's a legitimizing work that's also being done, and then there's an obstacle creating work that's being done. And again, it can't be all things. So I think you want to think about that a little bit. I think you want to be a little bit more, I think you want to push yourself a little bit more to think about, what is this a case of? When I'm done looking at this, what can I produce that someone could take to a totally different court? And maybe in this way, I kind of am then also saying what Johanna was saying in a way. Be careful in terms of, like, I don't know that you need to go to look at all these other transitional justice places. I'm not sure how much it matters, how many cases there are. I think doing the kind of a more narrow reading, a detailed reading of this place that you know so well, and maybe it's these particular defendants, maybe it's before these particular institutions, maybe it's the kind of narratives that people are being asked to accept or not accept, right? But I think that the case of Colombia is in and of itself, I think that this kind of a micro focus on that would be capable of producing something that would be applicable in other places. Anyway, I hope that is helpful. It's a great project. I encourage you.
Thank you so much, Kerstin. And can I invite you back to respond with your thoughts on some of these comments, Sofía?
Super. No, of course. Thank you. Well, thank you so much, Johanna and Kerstin. It helps so much. You already know, engaging in a PhD thesis, there's a lot of self-doubt. So, the encouragement is obviously, I appreciate it a lot, but also the challenges that you say I'm facing definitely are the ones that I'm getting into, and you gave me very good insight into how to do that. I think the concept of me theorizing about criteria is very useful. I sometimes have difficulties in saying that I am theorizing about things. Like, I feel uncomfortable saying that. So that it sort of gives me permission. I think that's super useful. I definitely think that my anthropological eye gets in the way of my legal eye a lot of times. This is a main challenge. My supervisor is the nicest person ever, and he really doesn't make me feel bad about that. But definitely my audience, I'm speaking to a law school, so I've been building up capacities to talk about this. So just the first part about the interdisciplinarity, I'll talk about that, and then a couple of comments that Kerstin made, and then finally what Professor Getchua, I don't know how to say that name, I'm sorry, asked. So in the interdisciplinary thing, or the intersection between law and anthropology, I definitely think that that's what I want to do. I want to find something between fields. I want to push the limits and the boundaries of each field. What I've gotten to is that requires a lot of respect for what works within each field. And I felt more comfortable respecting what works in anthropology than what works in law, because in the legal field, there's a lot of resistance to do this. So this is like my constant struggle. I'm trying to find ways in which the legal field can question the methods without it disappearing. I don't want the legal field to disappear, right? But sometimes I feel that I come in with methodological questions, and the legal field and the people that were in it are like, well, how is this question even useful? Like, what you're saying is just adopting social sciences, and that's okay, that's great, but nobody cares. I don't know how to say this, but it's like, it's the resistance that I felt. It's sort of, how do you advance in the legal field with a question like this in the intersection? But I feel that, and also teaching to undergrads about ethnography and law, I found that there's something there worthy of looking at, because it's the question about when something empirical is relevant. If we can theorize everything from legal doctrine and from legal concepts, then why do you need the empirical work? It's a lot of time, it's a lot of resources. It sort of makes the case singular. So, okay, your case is great, but how does that even affect the rest of the law and the legal field? But I think that in times like these, and this connects to the professor's question of ongoing conflict, the empirical part is super important. That's when I think that the legal questions should narrow down to what is going on and how this looks like, even for legal practitioners. So this ethnography has been fun, but also very enlightening about my positionality, because it's an auto-ethnography in a sense, because I worked as a practitioner and I know a lot of them, and I respect the work that people do. And of course, the trajectories of victims in this transitional justice mechanism as well is very important. But sometimes in the ethnography, I feel like a total outsider, the technicalities of some of the judges in the judge's mind and what's going on in the courtroom, but also how the perpetrators relate to this. This new perpetrators, for me, in a sense, seeing them as respondents before the special jurisdictions, which are the military and state agents, has been super novel for me. So I also feel like an outsider sometimes. So I'm trying to like grapple between that and what that means. In terms of, I would just mention something that Johanna said. I'm trying to bring in cases from other countries just to enlighten the context of what I'm looking at. So if I talk about Nuremberg, is because in Colombia we talk about Nuremberg, not because I'm looking at the case of Nuremberg just to see the context of it. So I think that is too broad for my PhD thesis to do a in-depth comparative work with the Rwandan case and the Yugoslavia case. In this case, I brought this comparison because it's the one that I can compare sentences with, but of course it has a lot of scale and particularities when we want to compare. So I'm not trying to do that. But what I'm trying to say is that even if it's only the HEP, or even if it's only Justicia y Paz, if it's only in Colombia, in some cities, I think there's something being said about the rule of law. I don't think that is something only particular to this case. That is a big challenge, but I think that that's what I'm getting to. And that's why theorizing rigorously, as you said, Kerstin, about the concept of repetition is important, so that anybody can then take the concept and use it for other things. I at the end, there was a question about, you said about efficiency, and I agree. Like, I think that repetition can be positive, negative, and neutral in a sense. What I found is that in criminal law, repetition really seems a bit incompatible. Like when you're talking about transitional justice, you have limited time. You have 20 years to do this. You have 20 years to prosecute all these people. And you have this judges and this victims, and you need to do those most responsible. Well, having hearings where the prosecutor is saying the same thing, so he's betraying or naming names, and nothing happens to those third parties, mainly because it's his word against theirs, and the others are saying, the ex-president is saying, I never did that, I have nothing to do with that. So it seems like a repetition that is wasteful. But I agree with you that there's something positive. So in part of my fieldwork that I'm doing now, I added a question about innovation. So how do all these actors that participate in these hearings feel that if they repeat something, or if they bring the perpetrator again to talk about this, or if they ask the same questions or the right questions, they will get a repetition that is productive. And finally, when he says this before the jurisdiction, then it will make sense to explain the paramilitarism in the way that we want to explain it, or to get to those other responsibles that we haven't gotten to. So what I found with the innovation question is that it's very important to me, mainly because I don't want to be depressed. Like I worked 10 years as a practitioner, and I don't want the conclusion of my thesis to be that there's nothing to do. So it's just something that I think, like, ethically, I think it's important. But I found super hard to get for the interviewees to engage with the concept. Because when talking about what works and what the functions of this and what this happened, there's a lot of negative views of this. I still have a lot of interviews to do, and a lot of other participant observation, but I feel that there's a negative take on this. So I'm trying to pivot it. Possibly I will have to do it by myself and more theoretically, because the world today is very difficult. And I think that this relates to Professor's question. So I do feel that transitional justice is still an option, maybe not in the same way that we know it, for ongoing conflicts today. There's a lot of politics that gets into this, of course, and this is a political concept and is a political tool. But I think making the right questions about how it works can eventually make adaptations to ongoing conflicts today. This comes from two convictions, I think, that are very important. And it's because I was a practitioner, I work in peace building. So I think that peaceful way out to conflict is necessary. I won't abide to any other conclusion. And I feel like when we discard transitional justice and when we discard alternative measures, I think the alternative, what we're saying is that the conflict must go on and resolve itself as a conflict, if that makes sense. I understand the position. I don't agree. I think that every time we say that, it just means we need to kill more people or other people need to be killed. And I don't understand that. But so theoretically, I'm trying to get over that with this other conceptual tools that I think can bring novelty to the transitional justice framework, which can be obviously very much criticized. There's a lot of problems and challenges. There's a lot of money involved. But I think that those questions are still worthy of asking, if that makes sense. But I do think that acknowledging that it is a political choice, it is definitely a political choice from beginning to end. Being transparent about that could work better, in any negotiation, in any conversation about these tools. And I felt that the last thing I wanted to say, that in my presentation, I wasn't clear that the declaration of what is being repeated by Mancuso is not resolved. There's not an answer about this. This is why it's still ongoing. So it's something unsettled, and that's why it keeps on going, and that's why it is an opportunity to know what it's doing to the law.
Thank you very much, Sofía, for such an insightful and stimulating presentation. Your work makes a valuable contribution, as colleagues have pointed out this afternoon, to ongoing discussions in transitional justice and has given us much to reflect on. My sincere thanks also to our excellent discussants, Dr. Amaya-Panche, who has had to leave a few minutes ago, and Dr. Carlson, for their thoughtful and engaging feedback, and to everyone who joined us today for your participation and support. The Global South Network warmly welcomes PhD students from all disciplines and from around the world to share their research and receive interdisciplinary feedback. If you are interested in presenting your work or participating in a future session or know somebody who does, please feel free to contact Dr. Norman Royat, founder and convener of the network, via the email address shared in the chat. Thank you all, and see you again in due course. Bye.